If the president does something illegal, it's for the court to say, no, that's illegal, leaving apart the question of enforcement. The proper mechanism is impeachment and removal. That's what the president... You laugh. But that's
sure.
That's the way this is supposed to work.
Hello, everyone. This is George Conway Explains It All to Sarah Longwell. He's George Conway. I'm not Sarah Longwell. I'm her best friend, JVL, sitting in for Sarah while she is out. George, another bad day at the Supreme Court for the Trump administration this week, although maybe, I don't know, I found ways to worry about it. We had a decision. The case was Department of State versus AIDS Vaccine Advocacy Coalition. This is really, everybody just talks about this as the $2 billion USAID payments case. The fine print of which is USAID had a bunch of contracts with people pre-existing before the Trump administration. The people on the other side of these contracts executed their part and simply wanted to be paid for the services that they'd previously agreed contractually with the U.S. government to provide. And the Trump administration wants to not pay those. wants to not pay those bills. We had a district court judge, Judge Ali in the U.S. District Court in D.C., rule that the Department of State could not refuse to pay it. He issued a temporary restraining order. The government went to the Supreme Court. You and I talked about this the last time we sat down together because John Roberts issued a stay of the TRO so that the full court could have a hearing of it. And we finally got a decision. That was this week, and it was 5-4. With the majority saying that, and I want to read the most important statute here, or the most important sentence in their ruling. Given that the deadline in the challenged order has now passed, and in light of the ongoing preliminary injunction proceedings, the district court should clarify what obligations the government must fulfill to ensure compliance with the temporary restraining order, with due regard for the feasibility of any compliance timelines. And that was them basically saying, we allow the district court's temporary restraining order to go into place, and we deny the government's attempt to have it overturned. Yes, it all seems very circular and technical.
It is. And it's not clear exactly what's going to happen now. But I think the significance of this case is the lineup. That it was 5-4. I mean, there are a lot of technical issues involved in the case about the mechanics of the spending. But the bottom line is you have 4 justices who, you have Justice Alito dissenting and basically saying there's no authorization for this. And it's sort of gaslighting the public. He's saying that, the courts have no business being involved in this. And here's the problem. This was appropriated money appropriated by Congress. And as you note, the payments were restricted to those people who had already performed their work pursuant to this appropriation by Congress. And yet basically they're deciding they're not going to appropriate anything. They're not going to spend the money that's been appropriated by Congress. And that's the fundamental problem. Now, the reason why it's more important than, let me see if I can explain this, than who's right in this particular case. Because Alito has a point. It isn't the role of, I hate to say this, that Alito has a point, even though he's really kind of gaslighting people in his dissent by saying there's no authorization for this. He's right in the sense that it shouldn't be the courts who are telling the president of the United States to do his job. And this brings up a larger problem, which I think is much more significant than the technical details of what happens in the district court. If you have a president who basically refuses to do his job, which we know when he raises his right hand is to faithfully execute the laws and the Constitution of the United States. But Donald Trump doesn't want to do that. And he's basically deliberately putting people in place who are going to stop the faithful execution of the laws, whether it be in this case, spending the money that Congress has directed to be spent, or in the case of the Department of Education, there's this talk of an executive order. Maybe they issued it, but an executive order providing for the abolishment of the Department of Education, notwithstanding the fact that the Department of Education was created by Congress, and all the money that runs through a lot of the money that runs through the Department of Education, if not all of it, are things that Congress says have to be administered by the Department of Education. He has no power to dissolve the Department of Education. If he wants to get that done, he's got to go to Congress. Congress has to pass a law, and then Congress has to figure out whether it wants to spend any of that money through some other agency or not. And this is my point. My point is, if the president refuses to do his job and affirmatively seeks to disobey the laws that Congress has passed and that presidents have signed in the past, that he is sworn to execute, then you basically, what do? You put the presidency in receivership? The courts basically become the Article 2 branch telling executive officials that, this is what the president should be telling you to do because it's the law, so you do that. I mean, let's leave apart the practical problems with that I've talked about previously, which is that the courts ultimately have no method to compel members of the executive branch to do their jobs, or obey court orders because the only enforcement mechanism is through the executive branch. But let's leave that aside. Let's suppose they could do that. It's totally insane. And this is what Alito is driving at, to have the courts basically perform executive functions. But they're performing these executive functions or directing that the executive functions be performed because the executive refuses to enforce the law. This is not the correct solution. And it's not the solution provided for by the Constitution, even though I think it's appropriate for the courts to issue these orders because their job is to tell us what the law is and say, executive, it's like the Steele seizure case. If the president does something illegal, it's for the court to say, no, that's illegal, leaving apart the question of enforcement. The proper function, the proper mechanism is impeachment and removal. That's what the president... You laugh. But that's the way this is supposed to work. The president doesn't do his job. He's supposed to be impeached and removed. But there you go. You have the people over on Capitol Hill who basically have abdicated their duties as well.
Yeah.
And the courts are left out there alone. And they have no method to enforce their orders. If they say something's the law, even if there's no dispute what the law says, like the birthright citizenship clause, which is as clear as day, or these appropriation statutes that say you shall spend this money, and the court has said in the past, if it says you shall spend money, you shall spend the money. You can't hold it back because you're the president. So what we have is essentially two of the three branches of the United States government, of a government of separated powers that the framers created to check and balance the powers of each branch so that we can preserve our liberty. We have two of the three branches abdicating their duty. And you can't have a constitutional system. You can't have the rule of law where 2/3 of the government is refusing to do its job. And that even leaves apart the question of the minority on the Supreme Court, who seem whose adherence to the Constitution you might question because of their seeming loyalty to Donald Trump. So, let's do the math here, right? You've got 2/3 of the government not functioning. And then at most you have 5/9 of the Supreme Court that is functioning, but 4/9 can't be relied upon. So you do the math most of the United States government is not doing its job and to protect our liberties and to preserve the rule of law. That's where we are.
I think it might be worse than that, actually. So the legislative
We're so optimistic
branch
on this program.
is clearly abdicating its job. The executive branch isn't abdicating its job. It has taken a different job and has decided
but that's abdicating its job in the sense that it's decided, its job is not to obey the law.
Right. It's decided that its job is to become an autocrat.
Oh,
right.
Right. Correct.
Yeah. And I want to read a passage from the dissent, which I think was kind of amazing. This is Justice Alito. Does a single district court judge who likely lacks jurisdiction have the unchecked power to compel the government of the United States to pay out and probably lose forever $2 billion taxpayer dollars? The answer to that question should be an emphatic no. But a majority of this court apparently thinks otherwise. I am stunned. That doesn't sound like legal reasoning. It sounds like talk radio reasoning. But
Correct.
When you get deeper into the minority's dissent, they do trot out some legal reasoning, and it's all about sovereign immunity.
Yes.
And I guess I'd like you to explain sovereign immunity, and I would like to ask you, is sovereign immunity the new presidential immunity?
No, I mean, sovereign immunity...
We're going to expand it and expand it and expand it to fit whatever needs to be fit to cover the actions of the Trump administration.
Well, here's why I was talking about how it's a little more complex.
Right.
Sovereign immunity is a legitimate traditional doctrine. And what it basically says is that, and it's not new, that the Trump administration the Trump administration or these Trump justices didn't invent it. Basically says that the government can't be held liable for things in money damages unless Congress provides a waiver, which it can do so. Like, for example, and here's what it is. If you brought a breach of contract claim against the government, you can bring that in the United States Court of Claims, which Congress has created. Congress allows you to bring those kinds of claims by waiving sovereign immunity. For example, there's also the Federal Tort Claims Act. If you're harmed by, you get hit by the president's limo, for example. Mm-hmm. Okay. And the Secret Service driver was negligent. You can bring a lawsuit against the United States under the Federal Tort Claims Act. And that's because Congress has waived the immunity of the United States to suit for damages. So this often happens in the law where there are two lines of authority or two doctrines that may intersect and collide. If you characterize this case as a suit for breach of contract, well then, probably should have been brought into the court. And I think that's what, I have to go back to the opinion, which I read only very quickly. But I think that's where the government was pushing this case. Like all these are breach of contract cases. Whereas the plaintiffs are saying, we are being harmed by the executive's refusal to spend money that has been appropriated by Congress. And he is violating the Constitution by doing that. And we have been harmed, and we have standing to assert that claim because the money was supposed to go to us. And there are basically cases there's a case called, I think it's Train versus the United States or Train versus New York in 1975, where basically somebody sued for saying that where the government, because President Nixon had impounded money and basically refused to pay out money that was going to go to somebody. And if you characterize the case in that way, it doesn't raise sovereign immunity issues. It's just a question of, how to enforce the law that says this money is appropriated. So, yeah, I mean, but this doesn't, that's why I went out of that box, that technical box, to go to the point that we have there's much more fundamental issue going on here about whether or not a case should be characterized as one for damages for breach of contract or one for, remedying a violation of the Constitution, although I think it is that. The problem is that if the executive fails to do his job, you end up with courts in a completely untenable position, even if they are able to enforce their orders, which they ultimately can't because they don't control the Marshal Service and the other mechanisms of the executive branch that are used to enforce court orders by a president who obeys his oath of office to enforce the law. So, in other words, that's a long, technical, theoretical, constitutional law, political theory way of saying we're fucked.
Okay, well, I'll agree with that.
Yeah.
The minority. So you're saying, correct me if I'm wrong, that they are making a hyper technical case that this should have been pursued. These claims should have been pursued in the claims court, not the district court. Right?
Yeah, I don't know that it's hyper technical. It is technical, but it sort of ignores that this isn't just an ordinary breach of contract claim where JV Last agreed to paint a wall in the Pentagon and has a contract with the Department of Defense for $10,000. It's not that.
Right. Well,
it's part of a large, massive violation of Article 1 of the Constitution.
Hey guys, JVL here. Spring's on the way, and with that comes the perfect time for a little spring cleaning, starting with your kitchen. Now, I'm not saying you need to become the next Iron Chef, but it's a great chance for you to level up your cooking game. That's where Hexclad comes in. This stuff, it's like if your favorite cast iron skillet made a baby with a high-tech spaceship. It's got the durability of stainless steel, the non-stick magic of a non-stick pan. It's sleek, and it does exactly what it promises. No more scraping burned food off the pan like it's the 90s. You just toss in the dishwasher, kick back, maybe watch a game while you wait for your food coma to set in. Hexclad's innovation doesn't stop there. Their Japanese Damascus steel knives are as sharp as they are tough, perfect for leveling up your meal prep. Their sleek pepper mill lets you season like a pro with precision and style. And Hexclad products also come with a lifetime warranty. That's right, these are literally the last time you'll ever have to buy these kitchen essentials. Our listeners, for a limited time, get 10% off your order with our exclusive link. Just head to hexclad.com/askgeorge. If you guys listen to these ads and watch this show, you know that I am an absolute sucker for good design, purposeful design. These Hexclad kitchen essentials are as good as they come. It's time to leave behind the delivery fees and that scratched up pan you've been clinging to since college. This year, cook like a pro. Remember, for a limited time only, our listeners get 10% off your order with our exclusive link. Just head to hexclad.com/askgeorge. Support our show and check them out at hexclad.com/askgeorge. Make sure to let them know we sent you. Bon appetit. Let's eat with Hexclad's revolutionary cookware. So here's my question about that for justice minority. Are they, is this a good faith argument? Like, do they really mean like, hey, we're just trying to call balls and strikes here? Is it the case that Thomas and Alito are not working in good faith, but maybe Gorsuch and Kavanaugh are, and they're trying to...
I hate...
Does it matter?
I don't think
maybe
it matters,
doesn't matter
but
what the reasoning was.
Maybe it does. It does and it doesn't matter. I mean, I always hesitate to get into the heads of these justices to figure out when reasoning is ill-motivated and when it is not. I have serious doubts, not just from this, but from many other decisions about the good faith of Alito and Thomas. Maybe in their own minds they're acting in good faith, but there's a lot going on there. And I do raise questions about that. But I do think that and Kavanaugh is kind of hard to figure sometimes. I do think that Gorsuch is very, very technical oriented. He's he's always trying to look for a clear line and a clear rule. And it sometimes leads him to results that you think, a justice appointed by Donald Trump would not reach. Like, for example, when he concluded that, essentially the discrimination against somebody who marries someone of the same sex is actually technically sex discrimination under the anti-discrimination laws, which is correct, actually. Logically, it's irrefutable. And that's, there was big controversy on the right about, oh my God, he voted with the gay people. But if the law says you shall treat people equally regardless of their sex, their gender, and it's like no error to it whatsoever, he's right. Of course, it also means that you can't engage in reverse racial discrimination,
right?
Affirmative action, which the liberals don't like, and they're being inconsistent there. But again, I hesitate to put my mind in their minds because it's hard. And I also think it's possible to overread what the majority did here, right? I mean, they don't clearly spell out their reasoning.
The majority decision's a page.
It's a page, and all it is just a direction. It's not which is normal for this kind of procedural order, which is based, on a stay application. It's very common for the court not to explain its reasoning and to vacate a stay or hold a stay without explaining its order other than to say, here's what we want you to do. And I'd like to think that there is some discomfort going on in the minds of the Chief Justice and Justice Barrett that is leading them to vote with Justices Sotomayor, Kagan, and Jackson. But we don't
put
know.
A pin in that.
We won't know. We put a pin in that.
We're going to talk about that later.
Well, we're also going to, we don't know. The pin in that is going to be on the wall for quite some time because we don't know how this is going to play out over the next year or two. When these cases actually go up in their full glory to the court, and the court has to actually write opinions that explain its reasoning.
Because again, this was just about overturning a TRO. This was not on the merits case about can the government do X.
Correct. Right? And for the, in that posture, I could explain the technical aspect. You don't know exactly why. It could be that they thought that, it just wasn't worth it. There are equitable considerations that go into this about who's suffering more harm than the other that may outweigh a determination on the merits.
Right.
There are all these practical limitations or practical considerations that go into a decision on a stay application that don't come into play on a full-blown merits case. And because the court doesn't explain its reasoning, we don't really know what motivated them. Right.
Well, we're going to get into, I have a full Kremlinology, Zapruder film level conversation we're going to have about the Trump interaction with Justice Roberts and Amy Coney Barrett at his not quite State of the Union speech, but we're going to do that in a minute or two. Hold on. The other big news from this week was Trump signing an executive order going after the law firm Perkins Coie. The Perkins Coie people did wrongthink by representing somebody that the Trumpers don't like, or because they hired black people. I mean, talk to me a little bit about this.
Well, yes, they hired black people. That's bad.
That's bad.
Yes.
Don't do that.
Right. And Doge, did you, just aside here, I like to wander around the environment. Did you see that Doge accidentally revealed a CIA black site in Northern Virginia? And the joke is
about that.
The joke is that they thought it was a DEI place because.
Yeah. Well done.
Let me. While I'm at the humor part
Well
of our
played.
show. Okay. Well, here's the
Enjoy
other
the
one.
veal. Yeah.
Here's the other. They pulled from a Department of Defense website a photograph of the bomber that dropped one of the bombs on Hiroshima or Nagasaki. I forget which one. Because remember what it was called?
Oh, the Enola Gay?
Gay.
Yeah.
They pulled that.
Get rid of this DEI crap.
So my joke is my joke now is wait till they find out about the Trans-Manhattan Expressway, the one that connects the Cross Bronx to the GW Bridge. And then there's the Department of Transportation. Transportation. The Transportation Safety Board. We got all these woke shit going all around the government.
Those trans people. It's everywhere.
Okay, let's go. Time to get serious again.
Okay, Perkins Coie. Talk to me about this. It's not good, right?
It is just a brazen abuse of government power and unconstitutional. And it's really amazing that the things that Trump is objecting to here or is seeking to punish Perkins Coie for are two things, basically. One is in 2016 or 2015, this firm was the firm representing, it historically has done work for the DNC and Democrats. And one of the things it did in 2016 is it engaged Fusion GPS, which had previously been doing opposition research for Republicans against Donald Trump, including paid for by that Singer fellow in New York. They also hired Fusion GPS to do some oppo research on Trump. And that this is what produced I forget the name of the Brit who wrote this report about the peeing in the bed in
Steele, the Steele dossier.
The Steele dossier. That was one of the products. So he's mad. He's still mad about that. Okay. Because I'm not sure why he's mad about that. Except, the peeing, I understand him being mad about with the prostitute. If that didn't happen, he should be mad about that. But the whole thing was basically to point his ties to Russia and that he's loyal to Russia. And what's the thing that he says last week, which was, Putin and I have gone through so much because of this Russia investigation. Me and Vlad, poor us. But let's set that aside. That's the first thing he's mad about is the Steele dossier and Fusion GPS. The second thing he's mad about is Mark Elias, who's this litigator who has really done an amazing bang-up job for the Democrats in challenging. This is a field of law. The Republicans do it too. It's a field of law where you basically try, to make sure the rules are applied in elections, in a ways that don't hurt you or at least or help you. Right? It doesn't, and they view that as criminal, even though these people basically are willing to steal an election. They accuse, they do, they engage in psychological
setting an armed
projection.
Mob to lynch the vice president, not illegal. Filing lawsuits,
it's illegal. And Elias is just an amazing. And the irony is, too, about Perkins Coie is that the guys who were involved in these two things are no longer with the firm. Okay? Elias now has his own law firm called the Elias Law Group, and then I looked up this other fellow, Michael Sussman, I think his name was. I think he was the one involved with it, but he's at another firm as well. This
isn't about punishing the people there so much as it is sending a message to everybody else in the future, right?
Well, Trump doesn't necessarily think, more than one step at a time. But that's his instinct is to punish those who he can punish. And, he's a bully. And so, that has the natural effect of intimidating people in the future. And then there is that part of the part of the order, of the executive order that talks about DEI. but also says that we need to investigate all the law firms, and that the agency head should look at all law firms for hiring minorities and women and whatnot.
So if a law firm goes down to like Howard to recruit potential black students, that's going to be bad, right? You can't do that anymore.
I guess, but if you hire Lena Haba, parking attendant lawyer, or parking garage lawyer, that's okay.
So here's my big question. This is a big old matzo ball right over the plate for you. To what extent is the law a guild mentality where all the other firms look at this and say, hey, this is bad for business, versus the extent to which it is a Shark Tank and people look at it as a zero-sum game and say, well, if they're going to hurt these guys, but we're on the right side, then it's good for our business?
That's the test. I mean, you're basically phrasing the question that we don't know the answer to that yet. There are some signs that are good because there are some law firms that are participating in these numerous lawsuits being brought against the Trump administration. But then there are clearly others, and I've meant like Sullivan and Cromwell, the guy was the best man at my wedding. I've told him directly to his face that I think it's a disgrace that he's representing Donald Trump. Well, I didn't, not in his face, but in a text, I said that, I'll tell to the world, I think he's a disgrace, that it's a disgrace. And I'm ashamed for him that he is representing Donald Trump in the criminal appeal. And his defense is, I'm just representing him on a criminal appeal. It's like, no, this man wants to destroy American democracy. Look at what he's done.
Everyone's entitled to a vigorous defense, George.
I just can't.
Womp womp.
Womp womp. You're basically, Hitler was entitled to a lawyer too, I guess, huh?
Yep.
And anyway, to go back to that, it's more like, you're right. I mean, there's the guild mentality, which should kick into play and saying, we are the defenders of this temple of law. And in
the long term, this is our business.
Correct.
Right? I mean, let's take the morality out of it.
Correct.
You don't even have to be moral. In the long term, this is the business of the guild.
Correct.
Right.
We live off the rule of law. I made a fuckload of money based upon the rule of law. Okay?
So that's my question. Which self-interest trumps which self-interest?
Well, the problem is, then the other side is not so much that you want to profit, okay? That, this is great. Perkins Coie is getting fucked and we can take its business. That was kind of the way you phrased it. It's more like, let's not have that happen to us.
Right, same.
Okay.
Same thing, right.
And then with what's going on with my friend who's representing Trump, maybe he never talked to me again, is he just likes to go down to Mar-a-Lago. Okay? He loves being in the center of the action, but not too close. I don't have anything to do with all this, right? So it's a combination of fear and ego, and that sort of drives some people to represent Trump and other people to shy away from calling him out or taking a position or showing solidarity with the people who are defending the rule of law, the very institutions upon which they make a living. That's that's how I would characterize it. And this battle is not over yet. And I am distressed in the sense that I think that it shouldn't be a question, that lawyers should basically band together and say, you're destroying the system that has brought us to this great point where we have, the greatest country on earth. Didn't need to be made great again. It had its flaws. We could work on them, okay, together under the rule of law. But it's easier to just sort of like look down and just do your business and represent, do your M&A work and your contract work and all that stuff, and just The more chaos there is in the market, the more transactions there might be, and the more legal problems people will have. So we just have to do our
near term. Don't worry about the long term.
Don't worry about your children. Don't worry about your freedoms. Don't worry about democracy. Don't worry about that. Let's just, this is not our role. We're just going to do our jobs. And yeah, they could do their jobs ethically for their clients.
Sure.
But isn't there more to life than just doing your little job and making money?
So this is really about the culture of the industry, I think.
It's about the culture of our country.
Well, that too. But in my, from an outsider, I always imagined big law as being kind of like the five families, right? You've got your big fish law firms, and I imagined that they all met together at the same club, and they were sort of happy to divvy up the world because the arrangement of the world was ultimately incredibly good for all of them. Like, as you said, big law made a fuck ton of money.
Correct.
And so I imagine that they would want to preserve that system for themselves. But maybe not. Maybe the ties are too weak, right? And maybe there are no remedies. That's the other question. So what are the remedies for this? Are there remedies?
I mean, the remedies I would think would be to speak out, would be not to represent the evil man who is seeking to destroy the system upon which your profession is based.
Right.
And to do pro bono work, to preserve the rule of law, as some firms are doing. That's the solution. But yeah, but it's part of an overall, that would be great if we don't have that culture of people just saying, basta, I'm going to do it, and I'm going to show some courage. I'm going to show some moral courage. We have this situation, and hopefully it'll change, but where people are just looking, it's like the prisoner's dilemma.
Right.
Like, if I go out and do this, I'm going to get smashed. So I'm just going to sit here. And then everybody else does the same things. They look, it's like, well, he's just sitting there. Why should I do anything? She's just sitting there. Why should I do anything? And there's and it would be great if people could engage in collective action to say,
right,
let's all go out there, let's all hold hands and jump together. But that's really, what we've seen at the Republican Party level, what we've seen over the past 7 or 8 years is it's really hard to get people to do that.
Very hard.
Even fucking Republican senators who have 6-year terms don't have the cojones to do that. And aren't going to run again.
Not going to run again. Yes.
They're just a bunch of pussies. Shameful.
Yeah.
Excuse my French.
I want to ask a delicate question. Dream with me for a moment, George. Dream with me that 4 years from now, your favorite Democratic politician has just been elected president. Okay, fill in the blank, right?
I don't think I have a favorite Democratic politician at this point.
Pick one, right? Should they do the same?
Gail Spanberger.
There you go. Governor Spanberger. Yeah, you see what I did there, Sarah? Has been elected president. Should she do the same sort of retaliation to the bad guy law firms who participated in all this?
No.
Or should she not? Because this is, I guess, the question, right? Do you retaliate like this to establish a tit for tat? So the idea is nobody does this in the future.
No.
Or do you, we're going back to the norms, which didn't actually help the Biden administration at all.
Okay, but let me say this. You don't do that.
Okay.
That being said.
Hey, everyone. Thanks for watching the show. If you want to catch the rest of this episode, then go become a Bulwark Plus subscriber. The link to become a subscriber is right below here in the episode description. Click on that, become a Bulwark Plus subscriber, catch the rest of the show, and support all the great work we do here at the Bulwark. Thanks, guys.
Well, George Conway, he's a man with a plan. Got to sit down with Sarah Longwell, take a stand, explain all the legal problems they're piling high. With Donald Trump, oh my, oh my, oh my. He said, Sarah, let me break it down for you. There's obstruction of justice, corruption too, the legal tangles and troubles, they're growing fast. It's a storm that's gonna last and last. Oh, Conway, tell Longwell all about it. Those legal problems can't live without it. From the Moldovans to the Russian ties. Oh, Sarah, listen close.